David Bernstein teaches constitutional law at the Scalia Law School at George Mason University. And he's been making the same argument for the past 20 years, but almost no one wants to hear about it. The argument is this: in Lochner versus New York, the case that every law professor points to as the textbook example of judicial overreach, well, Bernstein says that opinion wasn't wrong. But there were also a few other things from our conversation that I haven't been able to shake. First, that at the time of the Lochner ruling, 70% of newspaper editorials supported the ruling. Didn't oppose it, supported it. Second, that the man whose dissent became the battle cry against Lochner, Justice Oliver Wendell Holmes, well, it turns out that he was the only justice on that court with actual social Darwinist beliefs. And finally, Bernstein says the American system was specifically designed so that most people wouldn't have to care about politics. He says that's a feature, not a bug. Well, I had some questions about all of that. My name is Big John. These are the big questions. Let's get into it, shall we? What if the laws designed to protect your rights are the same laws being used to take them away? My guest today is a Yale-trained constitutional scholar who spent 30 years arguing what most legal academics won't say out loud. He says the Lochner era wasn't just a judicial disaster, it was a constitutional fidelity that we abandoned. He also says that anti-discrimination law, taken far enough, becomes compelled speech. Is this the administrative state overreaching, or is it operating entirely outside of our Constitution? My guest's name is David Bernstein from the Scalia Law School at George Mason University. I'm Big John, and this is the Big Questions. Professor Bernstein, welcome to the Big Questions. Thank you for joining us today.
Thank you so much for having me.
Yes, and it's very interesting when I was looking over some of your work, and obviously you're very influential in libertarian legal circles, and you certainly, in the great tradition of some of the more individually oriented thinkers. So let me ask you this, before we get into any specifics of the cases that I touched on, in general, what led you to the law, and specifically what most people would say a contrarian view a lot of constitutional legal principles?
Well, honestly, what led me to the law was that when I was growing up, basically, my parents expected me to be a doctor or a lawyer. And the problem, no, and I didn't like science, and I can't stand the sight of blood. But more specifically, once I was in college, I actually didn't really want to be a lawyer, but I didn't really know what else to do with myself.
Mm,
But at some point, I noticed that my professors seemed to have nice and interesting lives and got to spend a lot of time doing what they really loved, which is studying things that they were interested in. So, there are such a thing as law professors. I really am not from an academic family. I didn't know anything about being an academic, but I knew that Alan Dershowitz existed, and he seemed to have. Obviously, 99.9% of professors don't live like Alan Dershowitz and become celebrities and write about whatever they want. But that was my sort of introduction. It's like, well, he gets to write about a lot of interesting things. I guess you could be a law professor. And I looked into it, and basically I learned that if you got into one of the top law schools, that was your route. So I said, if I get into a top law school, maybe I'll pursue that. And when I got to law school, I found law very interesting and also very intuitive.
mm,
That's so it worked out well, and I enjoy it. And as far as being contrarian, there's an old joke about economists that the two economists are walking down the street, and one of them says, "Hey, look, there's a $20 bill," and the other one says, "Don't bother trying to pick it up. If it was really a $20 bill, someone else would have already taken it."
right.
So, so one fun thing in academia is to look for those $20 bills. And it turns out that if you don't have the same sort of progressive outlook, you haven't sort of adopted the same progressive prejudices. There are really a lot of $20 bills out there where there's a lot of things, especially historical matters, where there's just accepted dogma or accepted understandings of what happened, but when you think about that, you know it really can't be right, or at least something must be missing. So you just go and research it yourself, and lo and behold, it turns out that very often that's true.
So, correct me if I'm wrong. Did your sort of skepticism and your challenge of dogma? Do you think that did you have that prior to studying law, or do you think your study of in studying law that kind of sharpened that personality trait of yours, where you were like, well, wait a second, why is this necessarily true? Where's the proof that this particular doctrine must be true?
It's probably true that I'm a little bit naturally a skeptic,
Hmm.
personality wise, putting aside my intellectual interests. You know, um, I don't. It's I try to warn my children not to be like me, but when I was in school, I always had trouble maintaining groups of friends. I could have like individual friends, but
Right.
my groups of friends would be, oh, let's all go do this. I was like, well, I don't want to do that. Like, so why should I do that just because you do it? Well, answer is if you want to have friends, you actually have to actually go along with what other people want to do sometimes. But the kind of a lot of kids in high school like, let's all go to the school basketball game, and I was like, why do I care if the basketball team wins? What does it mean to me? Yeah, so there's
Right.
definitely a little bit of that. It also means that I think I have a personality where some people are really fearful of or feel really discomfort if they don't go along with the crowd, if people are somehow critical of them or, you know, think there's something, some problem, they have some kind of problem because they don't agree with them. And, when I was in college, I went to Brandeis University, which is a very liberal university. And I was kind of an outspoken, more conservative, at least in my early years, than libertarian. But, and people come up to me and say, how could you say those things or write those things in school paper? Everyone disagrees with you. And I was like, well, first of all, it's not true. There are people who agree with me, but never. But why is that even an argument? Like, I thought that was
Right.
just an incredibly stupid argument. Like the fact that other people think certain ways. What does that have to do? They could be right. They could be wrong. What does that have to do with me?
Right. Right. They're not addressing your actual the actual points you're making. They were just blanket saying, well, these don't align with the dogma, so they must be false, and you were pushing back against that.
Right. Or there's some attitude that you're here. You should be. Why do you want to be an outlier? I read. There's the old British TV show, The Prisoner. And
Yes.
my favorite scene from The Prisoner was there was one episode that for some reason they were trying to have, I don't remember all the details, but they're trying to have all the other residents of the island where the prisoner lives uh, be mean to him so he'd, break down and
Right.
confess. And every time he went out in public, people would look at him and then they point at him and say, unmutual, unmutual, unmutual. That's why I felt like people were telling me in college, you're unmutual. I was like, I don't have to be mutual.
Wow, a prisoner reference. That's fantastic. I think I could count on one hand the number of people in my life that have brought up the prisoner in a discussion. So you get points for that, David. Absolutely. Okay, so you started out, you went into law. Now, one of the things that you were initially built a reputation on, if I dare say that, put it in that way, was the Lochner case, which was Lochner versus New York, Supreme Court decision, turn of the 20th century. And it's one of those cases, to my layman's understanding of the case, where the dissent has had a much longer lasting impact than the actual ruling. If you agree with my statement there, but can you tell us why Lochner meant a lot to you in terms of putting across your ideas? Like uh, Lochner was the case of a baker. Uh, Please, or why don't you tell us? Tell us about the layman's understanding of the
Sure.
Lochner case and why it resonated, and particularly the dissents.
Sure. In the late 1890s, New York state passed a law that said that bakers may not work more than 60 hours a week or 10 hours a day, and there's no overtime. So that's a hard and fast rule. And that was unusual in those days because there were no maximum hours laws were just sort of getting started. And it was controversial because there was a sense that Americans are free, and one reason we're free and other places aren't is that we get to contract with people. And yes, government, almost everyone would concede the government has some role in protecting the public, but unless you could actually show that bakers were particularly vulnerable or particularly oppressed, it's in some way like It's one thing if you live in a mining town in the middle of nowhere where you basically can't get another job and you have to shop at the company store. It's another thing if you're in New York and there are thousands of small bakeries, and the bakery owners themselves aren't typically magnates of industry. They're just immigrants and so forth themselves. So it went through the courts, and the Supreme Court, in a controversial 5-4 decision, said the law violated the 14th Amendment, which implicitly in those days was said to include a right to liberty of contract, which could only be overcome if the government showed a legitimate, what they call police power interest. There's really some health or other public safety kind of issue involved. And the mere idea that maybe workers don't have the same bargaining power as their bosses in general wouldn't do it, but especially not in this case because, well, again, most of the bakery owners themselves were just, maybe had one or two employees. So the reason the case attracted me was really twofold. First, well, let me add, the case at the time wasn't nearly as controversial as its reputation leads it out to be. One of the things I did in my research, there was, everyone rejected Lochner and rebelled against it. I actually looked, like 70% or so of the newspaper editorials favored the decision. So it really wasn't that out. It wasn't really out there, but it
Right.
was seen as out there later. Once the progressives sort of took over, this was seen as outrageous. And for a variety of reasons, which I go into a book I wrote called Rehabilitating Lochner, the case became symbolic, first of all, of three different related but distinct things. First of all, the liberty of contract doctrine, which people rejected, once the society became, the New Deal came and progressivism sort of triumphed. Second, the Supreme Court more generally invalidating regulations. So Lochner was a 14th Amendment case, but there were other cases, and it was a state law. There are other cases involving how much does the federal government have power to do. And there's, for example, a case where the Supreme Court said they can't ban child labor because it's like Lochner, but the Supreme Court upheld child labor laws at the state level, and every state had a child labor law eventually. But they just said that's beyond federal power. So they're really two distinct issues, but they got lumped together. And the third thing is judicial activism in general. That this is the court. There's nothing. The 14th Amendment does not just says something about you have the right to not to be deprived of life, liberty, or property without due process of law. It doesn't say anything specifically about contracts or about hours of labor. So people on both sides of the political aisle at various times have used and continue to use Lochner as a symbol of illegitimate judicial activism. So what attracted me to the case? First of all, almost all the cases that people reject from that period, at least on that issue of liberty of contract, are at least debatable. And from my sort of more libertarian perspective, the laws were bad. That there was really that just in general laws that interfere with labor markets, unless again there's some special thing going on, typically are inefficient and often are benefiting some special interest or other at the expense of the public at large. And people would say like people would, and there's so much economic illiteracy around the discussions. People say, oh, well, this law was clearly going to help workers. Like, well, limiting the hours of labor may help some workers, but not other
Right.
workers. Like, why would you inherently? Why, if you limit the hours of bakery of work, then you get paid less over time, at least.
Right.
Right?
Right. Yeah. Yeah. And what's interesting as you talk about this is, I don't get the sense that you're kind of using an anarchist or a necessarily completely lawless sort of position, right? So if we talk to Rothbard or to Walter Block or somebody like that, and they would say, look, as long as the contract was voluntary and there was no fraud involved, people should be allowed to form any contract they wish, even if it means like, hey, I decide to sell you my kidney, right? Most of us would think that was ridiculous, but they would argue for that. But I don't get the sense that you're arguing from that perspective. It's sort of saying like lacking a public safety issue or something like that.
Right.
Uh,
Well, there's two
that
reasons for that. One reason is simply that as a law professor, I'm not a philosopher, I'm not an economist. I have to deal with the Constitution. And the
right,
Constitution doesn't say you could just do whatever you want. There's no the non-aggression principle of the Libertarian Party, whatever, is not built into the Constitution.
right,
We have to
right.
look at, so there's that constraint. I mean, I think the other constraint, and this is, I'm treading on thin ice here with some of my friends. Honestly, I think an issue that my favorite libertarian, let me just say this, is Richard Epstein, who's a law professor at University of Chicago. And the reason he's my favorite libertarian and not Murray Rothbard or Robert Nozick or Ayn Rand or
Right.
even Milton Friedman, who I also adore, is that because he's a law professor, he actually has to deal with real world. It's not
Right.
here's in our economic theory what the best policy is, or much less
Right.
philosophically here's like, you know, regardless of what your theory is, you're going to have to actually even if you had private courts and so forth, you're actually going to have to resolve disputes, and there have to be some principles to resolve them. So,
Right.
Rothbard, for example, famously didn't really have any idea of what to do about pollution
Right.
because
Right.
he said, well, it's he'll just say, well, it's aggression to pollute, but that means if I start a fire in my fireplace, some of
Right.
the
Particulates are going to get.
particulates
Yeah.
will go to my neighbor. So
Right.
is that aggression or not? There's no a priori answer to that, right? So
Right.
lawyers have to work this out.
Right.
So I actually like law that says I'm not really very philosophically inclined just as
Okay.
a personality type. And I also so that's one issue. But so we have these two. So I like to think about how we work this out. Okay, it's okay. Maybe the states shouldn't have a regulatory authority, but it's actually an interesting problem if we say that states do have regulatory authority to protect public health and safety. Where's that line drawn, and what kind of evidence do we need, and what kind of presumptions should we have is actually a very interesting question. And it's actually a very interesting question, even if you don't think the government should be doing this to begin with,
Right.
because you have to live in the world where they do have this power.
Right. Right. And in my simple brain, I kind of trifurcated the case. Right. You had who was it? Justice Peckham, I think, wrote the majority position. Right.
Yes.
That hey, the New York State overstepped its regulatory authority. Lochner was a German baker, and there's no evidence that they should set up their contracts. Justice Holmes was probably the most famous dissent, where he said, "No, New York had a very low bar to clear; that they were looking out for the public safety, public concern, policing power. They had that." And Justice Harlan's dissent was somewhere in the middle, which was, well, yes, the New York State does have an interest to have some regulations where public safety is concerned, but maybe they did, maybe they didn't in this case, or maybe they had proven it in this particular case, but that it was not absolute. Did I get that right? That there's
Yeah.
basically three levels of this decision.
Right.
That
So five justices in the majority joined Justice Peckham's opinion. And one reason the opinion became sort of notorious, I think, is that on a scale of 9 justices on the court at the time, he and Justice Brewer were pretty much neck and neck for by far being the most libertarian on economic stuff in the way they
right,
interpreted the law. In those days, nowadays, when you write a Supreme Court opinion, every jot and tittle of the opinion is disputed by other justices. There are concurring opinions and dissenting opinions and concurring in everything but footnote 4. In those days, as long as the opinion wasn't completely outrageous, and sometimes the justices didn't even bother looking at it, they just assigned one of the
right,
justices to write it, and whatever. So Justice Peckham's actual holding was actually pretty narrow, but his rhetoric was more sweeping. But the rhetoric
mm,
was unneeded. I mean, to me, the key to the opinion ultimately is that it was really a fairly radical law. That's why you were able to get 5 votes, because Peckham and Brewer often said you can't. Government has very limited power, but they got to get 3 more votes. How did they get them? Well, one reason, I think two major reasons. One reason is that the law had no provision for overtime. So this
mm,
was really, in some sense, a draconian law for the owner, because imagine you had a big order coming up and your
right.
business depended on it, right? And you said, "Hey guys, I know that your workday is supposed to end, but I'll pay you triple your normal hourly wage if you'll stay an extra hour to finish this order." You go to jail for that. Uh,
Right, and I think I'm sorry to interrupt, but to me it's fascinating because Lochner, to me, I get the impression that it was a typical family-owned German bakery that you see to this day in New York. You'll find in the outer boroughs, like just these German family bakeries, right? So this is not a conglomerate we're talking about that was putting 1,000 workers under some oppressive boot. It was probably a family-owned bakery, right? That just said, "Oh, look, we just bake bread or whatever, cakes or whatever." So in some ways, this was literally his livelihood, right?
Right. Now, I mean, this is not most of this is not really before the court, but it's a fascinating enough background that
Yeah,
since you
yeah.
praised it, so this it was actually not even in New York City, although that New York City was the big target of the law. He
Mm.
was a baker in Utica, New York. He had a
Utica.
family-owned bakery. He seemed to generally have one employee, and this employee is a really I found I looked in old newspapers, found very interesting. The employee was a 19-year-old guy when he started working for Lochner, and Lochner and the union came and said, okay, we're trying to unionize all the bakeries. And Lochner said, okay, I'm okay with that. And they
Okay.
said, oh, but one of the rules, if you're going to be a union baker, you're not allowed to be in charge of housing for your workers because then you have too much control. And it turned out
Mm.
the guy he had worked in had some kind of bad abusive family or get a lot of detail, but he's like, can't go live with my family. And Lochner says, look, I have this guy. I took him in. I'm treating him to bake stuff. I'm not going to throw him out just because you come and tell me I have to. And the union then was after Lochner. Uh,
Oh my goodness, I
uh,
didn't realize that. Yeah.
yeah, so they were like spying on this bakery to try and reporting him. And finally, Lochner got tired of it, so he joined with the Master Bakers Association, the other bakery owners, and with his employee created a test case. So his employee rat on him, but the employee it was sort of a setup case.
I
Uh, but and the reason this is kind of interesting is because the only way you really ever got caught violating this law is if the union reported you. What does that mean? It means the unions could have overtime. Right? They could put in their contract, we work 60 hours, then get overtime. No one's ever going to bother them, even though it violates the statute. But the non-union bakery couldn't have overtime. And there's the overlay of ethnic discrimination. Lochner himself happened to be a German baker, but in New York City, the German bakers tend to be better established and more likely to be unionized. And it was immigrant French, Italian, and Jewish bakers who
Right,
tended not to be unionized, and they tended to have the smaller basement bakeries where,
right,
the 60-hour law was a hardship for them, not because people were really working 80 and 90 hours, but because if you are in a non-factory bakery where you don't have shifts and so forth, you need the bread, then you let it sit. While you let it sit, you take a nap. You
right,
then put it in the oven. While you put it in the oven, you either take a nap or maybe you go to the bar and
right, right,
nearby hang
right.
out with your friends. But you're on call for
But
80, 90 hours, but you're not really working that much.
right, right. Yeah, it's an interesting sort of context to the case. But as the case went, as after the ruling, um, why do you think that? See, to me, Justice Harlan's dissent, again, to my layman's mind, seems to be the most reasonable, whatever reasonable may mean, right? Seems to be the most reasonable sort, not ruling, but approach, right? Like sort of this hybrid model.
Right. So
Why?
yeah.
Yeah,
Let me go back to the
yeah,
opinion. So the
yeah, yeah.
majority opinion basically said there's a right to liberty of contract. The government has to explain why you're violating it. The government didn't do an adequate job. I said one reason was because of the lack of overtime made it really oppressive. The other reason was that they claimed it was law for health. It was for the baker's health, for public health,
Right,
but then they put it in the labor code. And then they had the bakery union help supervise the law. There's all like sort of background that Justice Peckham would have known because he's from New York, but
okay,
it wasn't necessarily in the law. So there's language to much to Justice Peckham's harm in his reputation. He basically says, "Hey, there's no evidence that baking is any less healthful than all these other common industries that we don't regulate: lawyers, doctors, carpenters." And for decades, people said, "Oh, he just made that up." Right? He. This is an
uh,
example of judges being they didn't realize how bad things were for bakers. But then it turned out that if you actually read the briefs, that that Lochner's lawyers filed a pretty extensive brief showing that actually, if you look at the range of employers, bakers are basically in the middle. They don't die at any higher rates than your average person. And if you
right,
just cited the brief, it said, as the brief showed, that would have been great for his reputation. On the other hand, Justice Harlan wrote his opinion. He agreed with the general underlying framework of Peckham's opinion, which is yes, there is a right to liberty of contract, and yes, the state has to show it's operating under its so-called police power, protecting the either public health or health of bakers. But he says there's a lot of evidence that baking really is unhealthful, and therefore that's sufficient. We shouldn't serve as we should be overriding that legislative judgment. The interesting thing about that opinion is that people say, aha, you see, Peckham, he made up the facts, whereas Harlan had all this information about studies of bakers that he cited. And I didn't actually do this, but I mean, I looked at all the briefs, all the lower court opinions. I have no idea where Harlan got this information from. It wasn't
Okay.
in the record.
Right.
And then a student who's now wound up going to Yale Law School himself, is now a lawyer, he wrote a senior thesis. We actually found there was a pamphlet put out by the Bakers Union citing these old studies that Harlan somehow came across and cited, even though it wasn't in the record anywhere. But so it was really Peckham who had the actual evidence in the record, and Harlan who, and some of the studies that Harlan had cited went back to like the 17th century, so they weren't exactly the most up to date, valid studies. But anyway, a part of the point of my work was that both of those opinions were within the mainstream of jurisprudence in 1905. We agree there's a right to liberty of contract. We agree that the state can regulate when it's protecting public health or safety or morals.
Right.
But we disagree on whether the state, on how strong the presumption in favor of the legislation should be, and how strong the evidence presented by the parties is. Holmes was out all the way in left field saying, maybe the most extreme case where we can all agree that a law is oppressive, it should be held unconstitutional. But other than that, the government should be allowed to do whatever it wants, which was, very radical for its time. But within a decade or two, became the progressive norm in legal thought. Holmes himself was not a progressive, but he had a lot of young progressive fans who thought he was a godlike figure. If you have libertarians, your audience, is actually a little interesting twist here, which is that the most famous line from the opinion is the 14th Amendment does not enact Mr. Herbert Spencer's social statics.
Yes.
Now, Herbert Spencer was a great libertarian theorist of the late 19th century, mid to late 19th century in England. His influence had pretty much waned by 1905, but Social Statics was a book that basically adopted the libertarian, what we now think of as a non-aggression principle. Do whatever you want as long as you don't harm others. And that's what Holmes was getting at. There's nothing in the 14th Amendment is not, he's saying, a libertarian document, and therefore we should not interpret it in line with that.
Right.
But your average academic for the last 120 years, and actually a little survey, no one knows what this book is. All they know is that it's Herbert Spencer. I've read the book, but they haven't. Yeah. And Herbert Spencer is known unfairly and inaccurately as a social Darwinist. So they've said for years, hey, see, Holmes is revealing the true underlying ideology here. They're really just social Darwinists who want workers to be crushed under the oppressive boot of the capitalists. I mean, there's two ironies there. One irony is that that's clearly not what Holmes was saying, if you understand the social stacks reference. The other irony is that there's no evidence that any of the justices on the court were social Darwinists, except for Oliver Wendell Holmes.
Well, that is ironic. So coming out of this decision in this era, we see that this decision sort of says, like, okay, we're trying to preserve the right to private contracts, and sort of now it would. I've also read that this was presumed to sort of be a validation of laissez-faire economics, right? That the court. But is it fair? Do you feel it's fair that that was what the majority was doing, to put their sort of validation on laissez-faire economics, or do you feel that was just an interpretation that was used later?
Yeah, that's unfair. And to my own shame, one of the first articles I wrote about Lochner had the word laissez-faire constitutionalism in it, because that's what people called it. But as I investigated and did my own research, I discovered that, if you really mean laissez-faire, if you mean Herbert Spencer or Milton Friedman or whoever the equivalent would have been back in the day, William Graham Sumner, no one on the court was advocating that. Even Peckham and Brewer, who I said were the most hardcore anti-regulation justices, still voted fairly most of the time to uphold your basic health and safety
Right.
laws and so forth. Even in Lochner itself, the hours law was at issue, but the law also banned certain kinds of bakery practices, like keeping a lot of bakers used to keep cats in their basin bakeries. Why? Keep out the mice and the rats. Problem is
Right.
the cats would sometimes nap on the the dough and use it as
Right.
their litter box. Right? Okay. Well, right. So
Right. Right.
you could still argue that, if you're really laissez-faire kind of guy, because they still argue, well, that could be left for private people. We could have private sorts of regulation, or we just buy the bread from reputable bakers that we know don't do that. No one was arguing that that was unconstitutional. Those kinds of,
Right.
or sewage. You can't have sewage running through all that. So no one was laissez-faire in that sense. The real question was, at what point, where's the line between proper government regulation and the government either infringing on fundamental rights without a valid purpose or engaging in what they called in those days class legislation, which is sometimes misinterpreted to be like any kind of public choicey, special interest legislation, but it really means it's really about the classification. You're saying that bakers can't work 60 hours, but nobody else. Why just bakers? You have to have if you're going to single out any kind of group in society for a legislative classification, we understand every law is going to classify in some way, but if someone challenges and says, hey, this classification seems entirely unreasonable, you have to be able to justify it.
Right. And I think then as we progress now, okay, this decision occurred, then how did this become a progressive weapon though, as in the coming, say, century, right? How did it become that this became weaponized for judicial activism, say when it came to civil liberties or when it came to bodily autonomy or something to that effect? How did it morph? Because initially, one may have said, well, this was judicial active. If you were a progressive back then, you would say, well, this is judicial activism imposing their laissez-faire beliefs where there are none in the Constitution. And then, so if you were a progressive back then, you would have said this is a horrible decision because, it's imposing the judge's uh, opinions on economics here. How did this then, in your opinion, flip over to the progressive wing saying, oh, uh, let's use it for our judicial activism when it comes to things like civil liberties?
So if you look at the Lochner case itself and the subsequent history, while Lochner talked about liberty of contract as such, it was really not that liberty of contract was this super special thing, but that there are certain important rights that when the government is infringing on them, they have to have what we call that valid police power uh, rationale for it. So by the 1920s, the court was applying this not just to contract and property rights, but there were cases, for example, where, well, these are the most important ones, where the government tried to first ban the teaching of foreign languages, even in private schools, and then try to ban private schools entirely. And there's some liberty of contract elements there, like they're private schools, but the court also issues these broad opinions, 9-0 or 7-2, depending on the opinion. 9-0 say you can't ban private schools, with Holmes uh, almost dissenting, but dissenting in the first one. But in any event, the court says not only do you have the right to liberty of contract, you have the right to freedom of religion, the right to marry, the right to this and that, all these other things. And if the government's going to infringe on any of these rights, it has to have a valid police power rationale. So fast forward to the 1930s, the progressives take over the Supreme Court, and they have a choice to make. So they want to stick to the principle that we hate all of these 14th Amendment opinions protecting rights, as we've been saying, or do we find value in some of them? We don't like the economic stuff, but maybe the government shouldn't be allowed to ban private schools, especially when we know that a lot of the impetus for the ban was hostility to immigrant communities. Maybe the government shouldn't be able to engage in any kind of legislative classification it wants, including, say, with regard to race. Maybe race should be we should be suspicious when the government suddenly decides that black people should be classified differently than white people. So they tried successfully in terms of their own
Right.
satisfaction to say this isn't Lochner. These are these are first first of all, will preserve the opinions of that era. And then they went on to add in the 60s and early 70s birth control and abortion. And they changed the doctrine a little bit. Now it's like not in general, we have lots of important rights, and the government has to have a police power rationale. They changed the doctrine to there are certain rights that are truly fundamental, and those rights the government has to have a compelling interest. So there are fewer rights, but the government has a stricter standard in meeting them. And
Mm.
not surprisingly, first progressive critics of this trend said, well, this is just, they didn't call it Lochner yet, but this is just like what the court was doing back in the bad old days before the New Deal. Then once the older progressives died out, conservatives like Robert Bork came around and said, you guys are being just like Lochner. Meanwhile, remember I said that one of the other arguments about Lochner was it wasn't just about liberty of contract. Progressives said all these other cases where you're limiting the government's ability to regulate through federal legislation, through the taxing power, through also those are all really the same idea. So the progressives didn't take the what they would call conservatives of the pre-New Deal period at face value. They said, yeah, they had all these other doctrines, non-delegation doctrine, the Commerce Clause, and the 10th Amendment. But it was all really just about helping big business and crushing the working man. So they're all just Lochner. And so we wound up with this weird dynamic, which is when liberals or progressive justices were trying to protect abortion rights or other or contraception. I think the conservatives would say, you're a Lochner. And then the conservatives would say, well, but we have to keep the federal government within some constraints. The federal government is one of enumerated powers. Unlike the states who have a police power, federal government can only do what the Constitution says. And the liberals would say, oh, no, you're being like Lochner, because they each had different conceptions of what the real problem with Lochner was. So both sides now will attack the other side for following Lochner. And when I give talks about this to students, I always say it's a really silly. I mean, just defend whatever way you're using the Constitution or not. Whether your analogies to Lochner are completely post hoc rationalization of the reason you don't like the other side.
Right, right. So it just became a hammer to swat a fly or something like that. Um, from what I could tell, wouldn't one of the key principles in addressing like a Lochner type situation would actually come down to the evidence? I mean, typically we think of the Supreme Court as being more philosophical than the lower courts, right? The lower courts, again, my perception as a layman would be the lower courts are for things involving details and as you said, maybe pages and pages of expert testimony and evidence and things like that. Where by the time it gets to the Supreme Court, those are really cases for constitutional law, more high-minded, generalized principles. Uh, do you agree with that? Just my assessment overall, and then if you do, what role does actual evidence play
I mean,
when
this is a
these?
really hard question. This is, if you want a sort of the strongest critique of having the court review Lochner like legislation is that once you concede that the government has a valid constitutionally protected interest in protecting health, safety, etc., courts in general are not especially well suited to investigate that. You could argue that the legislature itself doesn't, but at least they hold hearings, they have public comment. All Supreme Court, all lower court justices will get our briefs, and maybe they'll have expert testimony. But then it's really hard. It's all, and also you're looking to some extent motivation. Were you really was this really a labor law? Is this really a health law? You have to. How do you decide that retroactively? So it's hard. And the Supreme Court itself is even less capable because they only get the record. They can't ask, hey, we'd like to know more about legislative history. We'd like to know more about what experts say. They do get amicus briefs, but it's not the same, right? There's no one to cross examine. So it is a very difficult issue. And that's a reason why you do want to be cautious about having the courts too involved in social policy. They're not, I mean, as bad as the legislature is at these things often, at least the public gets a say. At least there are hearings. At least there are means of correcting it with new legislation. Whereas courts are, look, just a bunch of lawyers. And this is one of the big critiques that progressives had at the time. Well, we have experts who could do this stuff. And the experts could testify to the legislature, or better yet, they could go to regulatory bodies like that can make their own rules without
Right.
when what do courts know? And that's why but that's also a reason why more conservative types tend to favor rules over standards. They say, well, and the Supreme Court tried to do this eventually in the 1920s. They tried to say, here is the 4 categories of laws you're not allowed to have, because otherwise we do it on a case by case basis, and it's just too much. Well,
Right.
you can do everything except like these 4 categories. You can't price fix. You can't set hours of workers without special reason. A few things like that. That's similarly why liberals, when they took over the courts, they said, "Hey, if we're going to protect African Americans from discrimination, we really shouldn't go and do what the court was doing in the past. Was this classification valid? Was it not valid? How do we know? We should have a presumption of it. We don't want to go case by case and decide, did the government really have a good reason for discriminating against African Americans? We're just going to presume that since humans are basically all the same, that there's no good reason to do it. But if you have a truly compelling interest, like when people say, well, what would really be a compelling interest, say, for segregation? So okay, let's imagine you are running the prison system of the state of Florida, and there have been a series of race riots between black and white prisoners. And as a temporary expedient, you put the black prisoners in one side of the jail and the white half on the other, right? That might be a compelling interest to tamp down the immediate threat of violence. But it's not going to happen very often. You don't need deep legislative findings to second guess the legislature. You're saying the legislature has to show. So a weakness, a both strength and weakness of the way the court went about things back in the old days was that they did do it on a case by case basis, which raises issues of their competency to do it, raises issue of bias. Maybe they're not the average Joe. They have class biases and educational biases and maybe ethnic biases, because a lot less likely to have Catholic judges back when Catholics are mostly immigrants. And it led to a lot of inconsistency. And even the Supreme Court itself, one prominent criticism was you have all these 5-4 opinions like Lochner. One day it looks like you can't have maximum hours laws. The next day it looks like you can, because a slight shift in perspective or a slight shift in how the law is written could change things. So you're raising a very valuable point, which is that the more standardy rather than rulesy, the thing is, well, our standard is that if there's an important right involved, the government has to show a sufficient interest. That's not something you can know easily in advance whether a law is going to meet that or not, and that's it's hard for courts to deal with, and expensive also to litigate.
Right. So, and again, forgive me if these are idiotic questions to someone who, like yourself, who understands these matters, but wouldn't then the Supreme Court just not take any cases that would turn on very specific evidence, right? Like we've heard of narrow and wide decisions coming from the Supreme Court. But like for matters of, say, that required where the whole case would hinge, like once we've established the framework of, for example, private contracts should largely be allowed, except where there's a compelling interest of the state via its police power, fair enough. Shouldn't everything below that just never reach the Supreme Court? Like if a specific case came about bakers or internet content providers or something like that, right? Like it should never reach that level, right?
I think you're showing that you should have gone to law school.
Oh,
because interestingly, because you actually intuited something that there's no reason you have any to know, which is that one thing that progressives noticed, which was that this Constitution doesn't really specify, except in a very narrow set of circumstances, when the Supreme Court has to hear appeals. At the time that Lochner was decided, if a law had been declared unconstitutional, the state couldn't appeal. So, in other words, if Lochner had won the lower courts, that would have been the end of it. On the other hand, if someone appealed lost on a constitutional challenge to a state law, then the Supreme Court had to hear the appeal. So this created something of a ratchet effect. Whereas if plaintiffs won, if a court had a capacious view of constitutional rights, that was it. You couldn't appeal to the Supreme Court. But if someone like Lochner lost, Supreme Court might uphold it, might also reverse it. So that led to a situation where the ultimate decisions of the court were more likely to push the law in a more libertarian direction. So the progressives figured this out, and when they took control of Congress in the 1910s, passed a new law that said actually Congress, the Supreme Court gets to decide which cases it wants to hear, which is the law to this day.
Right. Okay. So then it just literally becomes a politicized uh, issue of whether they accept a case or not, right?
So then that leads to, if a case is really fact intensive, the Supreme Court says, we're not really in a great position to make
Right.
a broad ruling based on contested facts. They could just not hear the case, let it stand until they get a case that is a cleaner, more obvious case where they could just rule on the law where the facts are undisputed, the facts are clearer, or the facts are really pointing one direction.
Well, then the next thing that this kind of naturally leads me to is the issue of facts and evidence, right? Because in those cases where the Supreme Court is taking a case that does seem to turn on facts, on evidence, um, you said earlier, for example, you can't, the Supreme Court is not equipped to deal with this back and forth that you would see in a lower court, where tons of experts testify, and there's cross examinations and everything like that. So, if a case that the Supreme Court does accept does, one would assume, hinge on evidence, um, how is that dealt with? And in your opinion, again, how does that affect our as individuals, our constitutional rights and our freedoms?
Well, that question just shows, like, this is why I spent like 20 years of my career on Lochner, because it was so fascinating. Because one of
Right.
the criticisms of Lochner was, and right away, in 1905, when the case came out that winter, Roscoe Pound, who was a leading progressive jurist at the time, wrote a piece for, I forget which law journal, saying, or maybe I think it was Roscoe Pound, or maybe it was anyway, one of the leading progressives wrote something right away saying, "Oh, the court was being formalist, was only looking at rights, wasn't looking at the facts. This is why we can't have judges doing it." Now, as I mentioned to you, Justice Peckham said that looking at these statistics, but they thought he was making it up. It was actually in the brief. 3 years later, in a case involving maximum hours lost for women only, Louis Brandeis filed a brief with all sorts of sociological data saying, here's why women, but not necessarily men, need maximum hours lost. They have weaker constitutions. Their pregnancies might not go well if they have to work too hard, whatever. And supposedly this was the first time anyone had ever brought a brief like this to the Supreme Court. The actual history is so much more interesting. So I told you earlier that the law in Lochner was sort of, maybe I didn't say this directly, was the unions wanted it because union workers were only working 60 hours a week and they could still get overtime if they needed
Right.
it. So this was a way of trying to keep out the competition. The head of the bakers union was a guy named Henry Weissman, who was a German anarchist who had been arrested in California for blowing up some business somewhere or whatever. But then he moved to New York and he became the editor of the Bakers Union Journal and a big shot of the union. He got into some scandal with the union. I don't know whether he was set up or it was true. It doesn't matter. And he quit the union or was forced out of the union. And what did he do? He opened a bakery himself.
Mm.
And then while he was running this bakery, he went to night school at what became Brooklyn Law School and became a lawyer. And when Lochner's lawyers brought the case to the Supreme Court, someone had the idea of, hey, you know who's a lawyer who actually runs a bakery, who knows more about all these statistics and data about baking than anybody? Henry
Right.
Weissman. Let's bring him in. So Weissman, they wrote a normal brief on the law, and then there was an addendum about all the data and statistics that then Peckham relied on. Uh,
Oh.
and so when Brandeis wrote his brief, it wasn't Brandeis's idea. People said, "Oh my God, we see," the people who really understood what was going on said, "We see the court was actually influenced by outside data that the other side brought in. We assumed they would just say, 'Oh, it's the police power,' but now the other side said, 'Ha, we're not just going to rely on the government saying that this is a health law. We're going to show you that it's really not a health law. There's no reason bakers and nobody else needs to be regulated.' So the progressive said, 'Let's hire Brandeis, and he'll write instead of having 20 pages, he'll write 200 pages about why women should in fact be regulated or allowed to be regulated.' And in my reading of the Supreme Court's opinion, they gave a nod to the brief because he was a famous lawyer. In my reading of the opinion, they just said, "Look, everyone knows women are different than men, so it's fine." And by the way, in case we didn't know that already, we also have this brief that reinforces it. But that became known as the Brandeis brief, and that became sort of a common thing that we now have, where not only do we have experts at trials and so forth, but then when cases go up on appeal, and especially the Supreme Court, experts will write briefs. And you know, it's actually problematic because these briefs are not vetted by anybody. They don't go in your tenure file. And if you read briefs written by, for example, historians on major issues, lo and behold, the historical facts as they relate them just so happen to always, I should say always, but way too often they happen to correlate with the author's pre-existing political views. And worse than that, they'll often get the briefs to be signed by 800 historians or 1,200 political scientists, the vast majority of whom never read the brief, aren't experts in the subject, and it's just phony expertise. It's, you know,
Right.
it's giving the patina or the appearance of expertise when it's really just political argument dressed up in expertise.
So, David, is this just something we can't avoid? Because the reason, excuse me, the reason, I mean, if you're interested in resolving a case, I'm assuming, maybe I'm being Pollyannish here, in the most just way possible, trying to adhere to the Constitution, and since as these cases become more and more uh, technical or more and more dependent on or hinging on facts, uh, I'm not a genius here. What would be a solution to potentially mitigate the effects that you just described, where it's just window dressing briefs and basically, oh, I like Brandeis, I'm going to sign on to his brief, as a quote expert or whatever. Um, how do we? Is there a way, or is this just something that's unavoidable when it comes to the law?
Look, I mean, I don't think there's any way of putting the egg back in the shell, so to speak. But uh, I think that if you would ask smart lawyers closer to the founding of the country that question, how do we solve this? They'd say, here's the way we're supposed. This is the way things are supposed to work. Legislatures, be they members of Congress or state legislatures, are supposed to take their own constitutional duties seriously. They're
Hmm.
not supposed to just rely on the courts, and they're supposed to actually think. Instead, so when they're the ones who have the facts before them, they're the ones that can gather the history. So they should be the ones thinking seriously about, is this really within our power, whether it be the Commerce Clause for the federal government or the police power for the states. And if they take that seriously and really argue back and forth and come to a serious conclusion that this was in fact within their power, the court should be pretty deferential to that. They should the court should not be trying to reinvent the wheel without having the first-hand evidence, and therefore the default position should be judicial deference. And I think that's actually the way life should work, and that would mitigate a lot of the problems. As it happens, our constitutional system has developed, so not only do our elected officials not take their constitutional duties seriously, quite often when a constitutional dispute comes up, they say, that's not our problem. Let's just pass the law. And if the courts think it's unconstitutional, then they'll deal with it. So
Right.
that does leave us back to your quite well, but then the courts are not really the place to deal with it, but we're leaving it to them. So courts, in a sense, are being asked to do fact finding and so forth that they're not really well equipped to do. And there's two ways of dealing with that. One way is to say they could do the best they can, and the other way is to say, try to be more restrained, still be restrained. If the legislature is not doing their duty, that's not really something the courts could deal with. The courts should say to themselves, we don't really know what we're doing here. Unless the law is kind of blatantly violating the Constitution, we should probably stay out of it.
What about, and this is hypothetical, but what about the situations where the court and just about everyone else sees an issue before it that the intuition everyone has is that the the case should go in direction A. Everyone seems to, by everyone, I mean everyone outside the justices seems to think, well, it should go way A, but restraint on the part of the Supreme Court, which you and I would probably agree they should have that sort of restraint when it comes to constitutional matters, not invent laws or have to do fact finding. That restraint leads them to the opposite of what everyone intuits, B. I understand the role of the legislature should play in that situation, but in that particular case, does it really fall to uh, public good? Because there are think say of the tariffs that were recently overturned under one clause, but then got reapplied under a different law, right? To me, it would seem like the underlying thing, like does the president have this ability to unilaterally tariff anyone and anything in what seems to be an unlimited fashion? Um, it seems like this is just gamesmanship, right? Because I think everyone kind of intuits that this should be a role for Congress, not for the executive. But restraint on the part of the Supreme Court would seem to indicate that, well, this sort of executive use of tariffs will go essentially till the end of the executive's term in this case, right? And you have real harm being done to businesses and to individuals in the meantime. That seems to me to be like a really bad situation to be in, right?
Well, so there's a guy named, I don't know if he's still alive, John Hart Ely, who wrote a famous book called Democracy and Distrust back in the
Mm,
70s. And it was one of these things that lawyers do, which is that he took a bunch of Supreme Court opinions that seemed not necessarily consistent with each other or have any coherent philosophy and tried to create a coherence out of it. And he did a pretty good job. I mean, probably not something that the justices themselves were necessarily thinking about, but he said, look, if you want to defend the progressive liberal opinions of the 50s, 60s, 70s, we have two basic things. First, we want to protect the underlying democratic system, right? Because what makes a law legitimate? The democratic system has to be legitimate, so we have to make sure the voting rules are fair and
right,
representation is fair, blah, blah, blah. Second thing is there are certain fundamental rights that we should all agree people have, and those include not having the government discriminate you against you based on your ancestry, right to free speech, and free speech actually is both things. It's important for democracy and is an important right, and so forth. So there's a limited number of rights and a limited and also democracy representation. What Ely did not add, which conservatives are trying to bring back, uh, is, well, what about the underlying structure of the Constitution? So the tariff case is something the court doesn't have to go into facts. The court doesn't really need to know specifically the tariffs. If Congress, there's two issues of tariff case. First, did Congress really give the president the authority to just tax whatever imports? But also, can Congress do that? At some point, Congress is supposed to be the legislative branch. So I think
right,
almost everyone would agree that if Congress just passed a law saying the president could do whatever he wants, as long as it's in the public interest, as long as he thinks it's the public interest, that would be Congress giving dictatorial powers to the president. That would be illegitimate. Progressives, though, since the 1930s, have had the position is, well, they can't do that, but they can say when it comes to tariffs, the president can do whatever he wants. Or when it comes to, they don't like the tariffs now, but other things, when it comes to regulating communications, like the original Federal Communications Act, the power they gave to the FCC was the power to regulate for public necessity, convenience, and interest, something like that. Like, just incredibly broad. It wasn't dictatorial powers in general, but it was basically dictatorial powers over this one area. Now we do have the Administrative Procedure Act, so certain procedures you have to follow, and it can be challenged, but basically progressives have been okay with giving the executive branch
yes,
dictatorial powers. Why? Because they like regulation, and it's a lot easier for one person to just regulate
right,
than to try to get 435 members of Congress and the Senate, 100 people in the Senate to then agree. So they've liked that, at least a more active government, but now they're real, and conservatives were traditionally kind of reluctant to exercise those kind of powers because they're conservatives. But Trump is not a traditional conservative, and Trump, is much more of an FDR type himself. That if you give him the power, he's going to take it and run with it.
sure,
But the sad thing is that as much as what progressives have been trying to do, they tried to do this in the Bush administration. They're trying Bush 2, and again, even more so with Trump. They're trying to make arguments that not that we should restrain this sort of thing in general, but that we have special rules for Trump, essentially. And look, that's just not going to fly. You either
right,
have to acknowledge that if you allow really broad delegations of power to the executive branch of the president, that good presidents, from your perspective, will do it. Bad presidents will do it. Evil presidents will do it. Whoever is president will do it. Or you have to acknowledge the Constitution has these limits. And this is just something. This is the the round peg they're trying to put in the square hole of, let's come up with a rule that will stop Trump from doing things we don't want to stop Trump from doing. But then if Gavin Newsom gets elected, it won't stop him from doing stuff.
Right. I think that's the a short-sightedness of the political cycles, right? I always say politicians never seem to be able to imagine their own mortality. So, they just assume that they'll be in power and we want this power. They never assume what their worst enemy would do with that same power. But do you find it surprising that the Supreme Court really, or maybe it has, in your opinion, has or hasn't tried to sort of push that across, that hey, let's take this seriously, and we're not going to rule on this because this is really a legislative issue?
Well, with the tariffs, again, the issue there was just at what point. Again, there was issues of statutory interpretation, not just the Constitution, but with a lot of these broad exercises of executive power, the underlying issue really is, at what point does Congress give away so much of its lawmaking authority that it's really letting the executive exercise legislative power. For certain things, for certain details, you're not going to have Congress, do every regulatory detail. Right. But look, this is actually a personal bugaboo of mine, because I think not only does the Constitution create three branches of government for good reason, and the legislature needs to legislate, and even the legislature is dysfunctional still. Part of the reason it can be dysfunctional is that they know they don't have to legislate. But that would be my position anyway. But I really, when I was a kid growing up and learning about political science and college and stuff, progressives tended to be like, why can't we be like Europe, where people really care about politics? Americans don't seem to really care. And to me, as a more libertarian, I was like, it's great. Most people shouldn't care about politics. Most people should go about their lives not worrying at all what the government's doing. And we had a system for most of American history where, for most issues, there were a few big ones like slavery, like tariffs, but for the most part, we didn't really worry who got elected that much. Right. Why? Well, there was a really good reason for that. You needed to get anything passed, you needed first to get through committees. So you already have, it's not a constitutional barrier, there's no committees, but it's something that we created. You have to get the right committees to agree, and you have to get the party that controls Congress is not going to let something through. So you already have that restraint. Then you have to get the median voter in both houses of Congress to agree, and then you have to get the president to agree. If the president disagrees, Congress has to feel so strongly that they override with 2/3. Right. So it's a very conservative with the small c system. It's hard to get legislation passed. What does that mean? It means unless there's really strong public opinion, a real wave, like in the 1930s or 1960s, right, we did have those waves, but they're unusual in American history, except in those really rare times when one side is really dominant. Nothing's going to change that much, whoever becomes president or whoever controls Congress. And therefore, most of us could just live our lives and not pay any attention to it.
And that's not a bug, that's a feature.
That's a feature. Right, exactly. Now, unfortunately, over the last 20, 30, 40 years, that has been diminished, partly because the parties are now much more ideologically homogenous. So it's much easier to get a party to agree on something because no inter-party disputes. But more importantly, because we've delegated more and more authority to the president, and Congress has been willing to do that. There were a few senators, like Senator Byrd from West Virginia, who really believed the prerogatives of the Senate. They're all dead. They're all the older ones. All the ones who believe this are either dead, or Russ Feingold was another one. Happened to be a Democrat. He got defeated. There are no institutionalists anymore who care about their own authority. They all want their own president to do stuff. What does this mean? So this means instead of legislation changing very slowly, or only when there's a huge wave of public support, the law changes drastically and dramatically in a whole variety of areas, even when a president wins a narrow victory, like Biden in 2020 or Trump now, or Trump in 2016, where he didn't even get a majority of the vote, just a majority of the electoral college. Why? Because he appoints people from his party to run the agencies. They have broad discretion of how to interpret the laws. And the parties are now ideologically split, and they don't even want to go to the center of the country. They want you know, if you run the Labor Party and you're a Democrat, you want to please the unions. You don't want to please even the median Democrat. You want to please the unions who are to the left of the median Democrat. So the Democrats come in, they make all sorts of pro-union regulations. Then Trump comes in and he'll reverse all those and make the opposite. Then the Democrats will come in and they'll do the opposite. And that's
Right.
true in environmental policy, in civil rights policy, in regulatory policy for various industries with global warming, and all sorts of things that instead of it being, oh well, the President Trump came in, but Congress is closely divided, nothing much will happen. Congress doesn't have to do anything. Trump issues executive orders and everything changes. And that's
Especially, right. I'm sorry, and that's because there's so much reliance on the regulatory function, right?
right.
Because those executive orders would be meaningless without, because the executive orders can only affect how federal agencies behave, right?
Right.
So without their regulatory authority, those would also be meaningless.
And the
So
regulatory authority is typically broad and non-specific. It's, regulate, figure out, it's, for the Environmental Protection Agency, it might be figure out what pollutants are out there and how we should regulate them. You have the expertise. This is the argument. They have the expertise that we don't. But these are not, and the old progressive conceit was that there's some kind of neutral expertise, and there are neutral scientists, or at least nonpartisan scientists, but the level of regulation, which things we decide are truly a threat or truly not a threat needs to be regulated, are not ideologically or intellectually neutral decisions. So they turn out to be political. There's no to take an easier example, there's no ideologically neutral decision of exactly how you figure out whether enough members of a workforce have signed their union cards to call for a union election. Like exactly, well, if someone signed it and then revoked it, does that count or not? Right? Those are not. There's no neutral expertise that allows for this. So the agencies are political. Even if the individuals working aren't political, the agencies have political decisions to make, and they're going to get ordered by the president. He's going to appoint the top people. And they're going to filter things down and say this is the way we want to do it. So we have drastic change. So we have something we've become much more of a parliamentary democracy, with a party that becomes it's easier to do this if you have Congress, but you don't even have to have Congress. You could be President Trump and have a Democratic Congress. You could still be issuing these executive orders,
right.
and Congress could do something. They could cut off the funding. They have some tools, but they don't have a lot of tools. And any tool they have that requires legislation, Trump could then veto. So
Right.
we're not meant to be a constitutional. We're not meant to, our system is essentially a parliamentary democracy. It doesn't have even the checks and balances that you'd have in a parliamentary democracy. So we have all the disadvantages of, if you see it this way, of drastic change happening back and forth, but none of the institutional advantages of parliamentary systems.
The guardrails, so to speak, of
Right.
parliamentary democracy don't exist here.
Right.
That's fascinating. And David, I'm sure I could talk to you all day, but then George Mason may have to start charging me tuition. So in that case, I thank you for your time. I appreciate the conversation. As I said, super interesting. I would love to sit and discuss with you and learn more. But right now, I want to kind of end the show on what I call the final five. These are 5 questions. There's no right or wrong answers. I just want the folks to get a sense of David Bernstein and understand a little bit more about you, hopefully through these sort of rapid fire questions. So number 1, pretend you're trapped in a broken elevator for 5 hours with any historical Supreme Court justice. Who do you pick for the best conversation, and who do you pray it isn't, because you'd end up losing your mind?
That's an interesting question. Who is the most interesting Supreme Court justice? I've met a few of them, and the one who would be most fun to be in an elevator with, as far as I know, is Clarence Thomas. He's a great storyteller. He's very funny, and he's just pleasant to be with. The most intellectually interesting, although he'd be frustrated because I don't think he'd accept some of my premises, and but it might be Scalia.
Ironically.
And the one who would be most interesting just to hear their life stories might be Thurgood Marshall, because before he was a Supreme Court justice, he would be going out, litigating for the NAACP in all white courtrooms in the South with risk of being lynched. He had a very heroic life, actually. And it'd be fascinating just to hear about it. So I didn't give you 1, but I gave you 3 with different.
That's fine.
The one would probably drive me crazy would probably be Holmes. I just think
Okay.
he was or maybe James McReynolds, because he was just a horrible reactionary and anti-Semite. So I probably wouldn't enjoy being with him on that basis. But Holmes just he had this patrician air about him, and thought, I think, a lot more highly of himself than his actual intellect deserved.
Okay. Fantastic. Um, Assume you could ram through one new constitutional amendment. What would the 28th Amendment say?
What did the 28th Amendment say? Um, wow, that's a good question. Uh, I don't know, the one that comes to mind. Let's take two that are actually plausible. One would be a balanced budget amendment, and
Right.
I think it wouldn't be a balanced budget amendment, but it would be, you have to be within a certain range, like anywhere from 2% -2% to +2% of the budget. I would have to have some considerations of not having budgetary gimmicks to avoid it, because otherwise it's meaningless. I'm not sure
Right.
if it could be done, but I do think that, racking up, the problem with financial crises is they occur when people lose faith in the underlying institutions, and you don't know when
Right.
you don't see it coming. So we could keep piling up debt, and everything goes. And all of a sudden, the people who make the big money decisions say, we don't have faith in the U.S. dollar anymore, or in the
Right.
faith and credit, and then the economy collapses, and we stay the current trajectory, it's going to happen. The other one is the term limits amendment. I think some of the term limits amendments that states passed were a little strict, like 3 years for a member of the House, or 12, 1 or 2 terms for the Senate. But I think at some point, um, you know, people should move on. If you're a member of Congress, run for the Senate or go do something else. Or maybe the related one is, this might be plausible already. I really think one problem with Supreme Court is we have the nine justices, and they stay on forever. And they have cults of personality around them, and a colleague of mine proposed this. This might already be constitutional, but if it's not, I'd have an amendment. Instead of having nine justices serve for life, I would say you choose the Supreme Court justice randomly for short terms, let's say 4-year terms, from the current judges on the federal courts of appeals. So instead of it being like this one really influential justice, who's either because he's an intellectual towering figure or because he's right at the center of the court, gets all the attention, you instead act like a real court, and it's not about you, it's about the precedent, and it sort of relieves the tension of, if one justice dies, everything changes, because that's not going
Right.
to happen.
So a rotating cast of Supreme Court justices,
Yeah.
and it would also put more importance on the federal
Yes.
circuit judges
Right.
being appointed. Right.
Yeah.
That's a good one. I like it. And of course, your balanced budget amendment is sort of based on, from what I'm understanding, on Milton Friedman's suggestion of having a rules based balanced budget amendment. So anything Uncle Milton says, I'm with.
Right.
So I'll go with that. Okay. Number three, when you're not working, what's the thing that would most surprise the people who know you only from your academic writings?
I'm a big fan of 80s alternative and 90s alternative music.
Oh, okay.
Yeah. So,
Throw
anything
out.
from
How's
new wave, ska, some forms of reggae, grunge from the 90s, all this stuff. No reason, I know my students are always surprised when they learn this, because they think, "Oh, you're a serious professor." One time they heard my Devo ringtone on my phone came off, from the song "Whip It." So yeah, that might be it.
I was going to say, throw us out your favorite band from the era.
Um, Somewhere, so I think I'd have to choose between Devo and the B-52s.
Two good choices, certainly. Uh, if the Lochner Supreme Court had gotten everything right, what would America look like today?
Most likely we'd have well, if we call the Lochner court the court of the era rather than just an opinion, I think we probably would have um, a somewhat smaller national government and somewhat less regulation. But I don't think law autonomously or independently can stifle social change in the long term. I think the court does a great favor in the 30s by slowing down the New Deal, right? Because some of the early New Deal legislation was really terrible. People don't appreciate how bad some of the original New Deal legislation was, but ultimately they couldn't stand in front of the wave. And, every other country in the world went with the big welfare state and so forth. And I assume the U.S., one way or the other, would have also.
Would have eventually gotten to that point, yeah. Okay, and the last question. What's the most useful thing a critic of your work has ever said to you?
Oh, that's a good one. Uh, when I was in law school, I had a professor who was a visiting professor from Ohio State, was a historian named Les Benedict. His name is Michael Les Benedict. He goes by Les, which I never understood because I think Michael's a much better name than Les. But anyway, Les Benedict. And, I was not a mature academic at the time. I'm not from an academic family. Um, I did well in college, but I wouldn't say I really absorbed, the academic culture that well in terms of really learning how to be a scholar. And he said to me, David, your work is really historically sound, but some of the accompanying language you use is much too tendentious. He said, someday, this hasn't actually happened, he said, someday Hillsdale College will be paying you $10,000 to give their endowed lectures. And when you do that, you're talking to that audience of people who want to hear ideological stuff, feel free. But for now, you need to sound like an objective scholar. Your work is good, so don't undermine it with tendentious rhetoric that you don't need.
So he got you a little more focused in your writings.
Yeah.
Okay.
A little more aware of how the writing comes off as opposed to the quality.
Excellent. Well, that was good advice, certainly, and I'll probably steal a little bit of that advice for myself. All right. Thank you, David Bernstein, for joining me today here on the Big Questions. Please, is there a Substack, a blog, a website you'd like to let our viewers know about?
Sure. Well, you can follow me on X at Prof. D. Bernstein. You could, and I blog fairly regularly at the Vol Conspiracy, which is VOLOKH.com, and at instapundit.com, and occasionally at timesofisrael.com.
All right. We'll find your work there. Everyone, thank you for joining us here on the Big Questions with Big John. Please hit the subscribe button. Also follow, give us a like. We really appreciate it. Until next time, when we do this again, peace, everyone.